Good morning to our guests in the United States, and good evening to those of you joining us from Asia, including our esteemed panelist, Thomas Cheng. Welcome to our third discussion at the roundtable, International Competition and Asia-US Trade Law, a Changing Landscape, brought to you by Roundtable Group. So, Thomas, good evening. We'll start with you, focusing on your part of the world. So tell us, what are the latest trends in antitrust enforcement in both Hong Kong and China?
Well, thank you, Dan. I'll start off with China, the largest jurisdiction, and I guess the jurisdiction of greater interest to those of you here. 2020 was a very busy year in terms of antitrust enforcement. For those of you who know, there used to be 3 enforcement authorities in the mainland, the NDRC, SAIC, and Ministry of Commerce. That was merged in 2018 into the State Administration of Market Regulation, SAMA. And so 2020 was, I guess, the second full year of enforcement by SAMA. And I guess it has, in terms of actual enforcement activities, it kind of continued the trend from previous years. Again, the bulk of the work, it was in merger review. And I think it's fair to say that the Chinese authority, previously Ministry of Commerce and now SAMA, likes to take its time. Review takes long time, even though the statute actually provides for a fairly strict time frame. But the Chinese authority likes to ask companies to withdraw and refile, and hence artificially extending the review time frame. Again, another trend is the Chinese authority rarely blocks a merger outright. I think so far they've only done 2, and they didn't block any merger last year. And I guess in terms of merger, a further, new development was for the first time, the Chinese authority recognizes a structure called the variable interest entity structure, which is what Chinese companies use to evade the domestic regulation that only domestic firms can operate internet business and e-commerce. And so the way it works is for internet businesses that like to get listed abroad or incorporate abroad. So what they do is basically have a domestic business that in theory owns the internet operation license, but it enters into management contract with the overseas entity. And the management contract is what ties the overseas entity with the domestic structure. And it was very controversial. No one really knew whether this kind of structure was really legal. The Chinese government never said a word about it until this past year, when it finally actually imposed sanctions on some mergers involving this structure, but I guess implicitly also acknowledging the existence of this structure. Previously, the Chinese authority had been very careful about not acknowledging the existence of this VIE structure at all. And so that, I think, was probably the big development for those of you who are familiar with Chinese e-commerce business and merger review. Guidelines. For those of you who are familiar with antitrust enforcement, you may know that antitrust authorities around the world like to issue guidelines. The Chinese SAMA finally issued the intellectual property competition guideline pretty much since, the Chinese government has been working on this set of guidelines for close to a decade. And there was a lot of false alarm. Every year or so, there is suggestion that, okay, the guideline is finally coming out, but eventually it never does. And so it finally came out. And I don't think there were a lot of surprises there. SAMA put forward a draft amendment to the anti-monopoly law. And the most noticeable feature is that fines and sanctions were raised quite significantly. And for the first time, the AML mentions criminal liability. Although what exactly it is remains to be seen, because the reference to criminal liability is quite cryptic. The anti-monopoly law itself does not impose criminal liability. It refers to if the conduct at issue otherwise violates the criminal code, there will be criminal consequences. But the criminal code currently has no provisions that cover conduct that's covered by antitrust law. I was going to discuss the Alibaba case, but I think I'll do that later on when we talk about the big tech. And in terms of Hong Kong, I'll just mention briefly, I think enforcement trend remains focused on cartel, although last year we finally had an abuse of dominance monopolization case, which was quite groundbreaking. But I think I'll stop here. And then if there are further questions, I'll elaborate.
Sure. Well, I was just going to ask you actually about big tech. What's the extent of the focus on big tech in antitrust enforcement in Hong Kong and China?
My answer on Hong Kong is very simple. There isn't any focus. And I think rightly so, because big tech, the cases are so complex and it's so resource intensive. It's quite unrealistic to expect an authority that has only been in existence for 8 years to bring a case against the likes of Google or Apple or Facebook. But in China, there is, in last year, we really saw a very distinct shift in focus to big tech, and in particular, Alibaba. The good news for GAFA is that because they are practically completely blocked out of China, so they have not been implicated at all in the antitrust enforcement in the mainland. But I'm sure most of you are familiar with Alibaba, and it probably was a tale of hubris. Jack Ma gave a speech. I think some of you probably have heard of the story. Jack Ma gave a speech in October criticizing Chinese authorities for being old-fashioned and not keeping up with the times. And I presume he has criticized Chinese officials before, but for some reason, this time it really grated the Chinese officials. And so, unfortunately, Mr. Ma forgot that Ant Financial, which of course runs Alipay, which is one of the two largest electronic payment systems in the world, was about to go public. And so the Chinese authority quite shockingly blocked the Ant Financial IPO. And after that, launched a number of investigations into Alibaba. And Alibaba has made very contrite noises saying we will cooperate fully with the authority and we will reform our business to make sure that we do not violate the antitrust laws. The Chinese e-commerce websites, the two main ones, Alibaba and JD.com, they both have a habit of requiring their merchants to choose one out of the two main websites. Basically, it means you have to, if you want to sell on Alibaba, you have to sell exclusively on Alibaba, and which is clearly an exclusive dealing situation. And if the entity involved has sufficient market power, would obviously raise antitrust concerns. And so, so the Chinese authorities finally taking a look into that. And so, short answer is there definitely has been a distinct shift of focus on the big tech, but we are talking about the Chinese companies and not really the foreign ones, because GAFA don't operate in China really.
Sure. Well, so switching to foreign companies, what are the enforcement risks for foreign companies in Hong Kong and China?
In both jurisdictions, foreign companies have featured in enforcement action. Two sides of the story really, with respect to merger enforcement and conduct enforcement. With mergers, I think pretty much the Chinese authority has only imposed remedies in mergers involving foreign entities. In merger review, the focus has definitely been on foreign entities. The Chinese authority, SEMA, and previously Ministry of Commerce, is much more likely to impose remedies in mergers involving foreign entities. In conduct enforcement, for example, cartel or RPM cases, there have been some, but in terms of number, enforcement action against domestic Chinese companies definitely counts for the vast majority. But the problem for foreign companies is because they have much larger revenue. And so the cases involving the largest fines have almost always featured foreign companies, because the domestic companies that have been subject to sanctions were generally fairly small ones. And so the fines were minuscule. So yes, I guess, I don't think you would say that the Chinese SEMA targets foreign entities, especially I don't think it's true in conduct enforcement. Occasionally there are cases involving foreign entities, and the fines tend to be large. But I think that's really the consequence of the fact that foreign companies generally, the foreign companies being sanctioned in these cases generally tend to be much larger.
Right. Okay, great. Interesting. And so kind of shifting the focus to the trade war between China and the US, what are the risks that antitrust enforcement will be used as a weapon in that trade war, would you say?
I mean, that is the elephant in the room when one talks about and Chinese anti-monopoly enforcement. I mean, as I said earlier, so far, I don't think one can say that the Chinese authority has targeted foreign companies in conduct enforcement at all. I mean, in any case, I think the vast majority of enforcement action involving anti-competitive conduct has been focused on domestic companies. In mergers, I think we have seen two instances where the Chinese authority can be said to be, I mean, there's suspicions that that political considerations were involved. I think in the first one in particular, Qualcomm NXP, it's pretty clear that it was politics that ultimately drove the outcome. Qualcomm tried to acquire NXP in 2018, and the notification dragged on, the review dragged on and on and on. Qualcomm withdrew its application, refiled at least twice. I mean, the merger was uncontroversial in other jurisdictions, but MOFCOM, the Ministry of Commerce, just would not act and approve or reject the merger. And this was at a time when the Trump administration was targeting Chinese tech companies. And eventually, Qualcomm just threw in the towel and said, forget it, let's just move on. And I think, I mean, in that instance, a lot of people agree that it was politics that drove MOFCOM's decision. More recently, Cisco's acquisition of Acacia Communications, eventually it got the approval with remedies, but the review took 450 days, which is a lot longer than what is statutorily allowed. And again, the merger did not raise any concerns in other jurisdictions, but the Chinese authority dragged on the review for a long time. I mean, they have done it before. This is not the only time, but given the political climate, I mean, one may suspect maybe politics was one of the considerations. But I mean, again, I mean, nothing is proven. But I think there could be valid suspicions that the massive delay was partly caused by political considerations. Mm-hmm. So, I mean, in short, I think American companies contemplating mergers, especially in the tech space, probably have more to worry than the other companies. I mean, so far, I mean, both mergers involve tech. And so if the past helps us predict the future, I guess one can say probably American tech companies contemplating mergers would have more to worry about.
Thank you so much, Thomas. At this point, I'm going to open it up for questions from our audience. If anyone has a question for Professor Cheng, you can either send it through the chat and I can read it aloud, or you can just write question and I can unmute you or ask to unmute you, and you'll just have to approve through Zoom. Anyone have any questions for Professor Cheng?
Thank you for putting this together. You know, I'm in the U.S. and we are dealing with a lot of litigation over information sharing and trade association membership. So I wanted to see, you know, what the enforcement trends are in China related to, you know, information exchanges, trade association membership, those types of issues.
Information exchange, if I remember correctly, I don't think there has been a single case involving that, or at least a single case in which that information exchange is the main theory of harm. Trade associations are complicated in the mainland because a lot of them descended from former ministries that actually managed a particular industry during the central planning days. And so trade associations in the mainland often have semi-governmental status. The AML has a separate provision, penalty provision for trade associations that are involved in that organize anti-competitive conduct. But I mean, there have been some small cases involving local trade associations organizing cartel. But I mean, I don't recall any of them being on a national scale of national importance. And in those cases involving trade associations organizing local cartels, I mean, they were fairly blatant. And so I don't think there's any dispute that what they did was wrong. But yeah, I would say information exchange, there really hasn't been much. And trade associations, there have been some scattered local trade associations organizing local cartels.
Thank you. That was helpful.
So we're going to switch gears over to you in the U.S., Steve Adkins. Hi, Steve.
Good morning.
Good morning to you. So, Steve, switching gears to the U.S., the focus of your practice is, of course, litigation under ITC Section 337. And I know the ITC handles various types of trade issues, but can you briefly explain the scope for our listeners of what Section 337 covers?
Thanks for having me today, Dan.
Thank you.
So Section 337 is a way to deal with unfair competition. It is not really politically dependent, at least not at the front end. Perhaps it is at the back end. If you have a competitor who is bringing in product to the United States, is importing product, and that product may be infringing your intellectual property, typically these are patent cases, about 97% are patent cases, you can go to the commission, and the commission will do a bench trial before a judge, extensive discovery. It's very much like being in district court, but it's a lot more work and a lot less time. So you're in trial in a few months, whereas in district court, you might be in trial in 2 to 3 years. And lately with COVID, it's even longer to trial. So the commission has this draconian power to block imports, and they direct U.S. Customs, if they find infringement, to seize products as they come into the border. So that's this unique thing that is the ITC with respect to 337. So it's not trade sanctions. I've had people say to me in the last few years, oh, with the trade wars with China and others, you must be really busy. And none of that affects this. This is really competitor to competitor.
And does the plaintiff or the complainant in a case before the ITC, does it have to be an American company?
No, it just has to have an American presence, some R&D perhaps, or a facility. For example, at one point you had Apple suing Samsung, and they were in a courtroom, in one courtroom at the ITC. You had Samsung suing Apple back. So Samsung, the Korean company, is suing on its U.S. patents. So you just have to have U.S. IP. You don't have to be an American company to sue.
Can you speak a little bit more about the customs orders that you mentioned?
Sure. There are really two types of orders. There's a limited order, which says to customs, these companies were named in the complaint, seize their products when they come into the country. And then there's the more fun, if you're on one side, perhaps less fun if you're not. That is a general exclusion order where you can sue people and not tell them. And I once told a friend, a guy who became a friend after he threw me out of his office in Hong Kong, in fact, in Professor Cheng's neck of the woods, your company has been sued. This guy had built up his company, had spent a lot of money because all of his competitors had been named in an ITC complaint. So all of those competitors' customers had been coming to him to buy product. So he had spent about $2 million building up his business, not realizing that this company who had sued was seeking a general exclusion order. And he said to me, there is no way you can sue someone and not tell them. That would violate the American dream. And it may well, but that is the case. If you go to the commission and make a certain showing that there are so many infringers, I can't identify them all. You get an order. You then go to customs and say to customs, even though this company wasn't named and this company may not have been in existence 3 years ago when I got my order, seize their products. So it's a remarkable remedy through customs that you can get.
So these defendants can be sued without even knowing, frankly, that they've been sued.
Well, technically that's right, but the law says that everyone, after they read their newspaper and drink their tea or coffee, read the Federal Register. And in the Federal Register, there's plain notice that these people have been sued. In reality, nobody's that bored. no one reads very few people read the Federal Register. They're usually getting paid to read the thing. But that's the due process. That's the way the law gets around the due process issue.
You said with a general exclusion order, even companies that are not named and don't participate in an ITC case can have their products seized by customs, however?
That's right. And of course, you can participate. You can intervene. You file a paper with the commission and say, my products are going to be seized. I want to intervene.
So what about inventory of imported infringed product? Can the ITC deal with those situations?
Yes, those are dealt with by something called a cease and desist order. And of course, those products necessarily are beyond customs. They've cleared customs. They are in warehouses in the United States. And those orders, unlike exclusion orders that customs administers, where there is no monetary penalty if you violate those, with cease and desist orders, there's quite a penalty. I remember several years ago, we were called by a company who had just lost the ITC and they wanted new counsel. So I went over and I said to this person who was the boss's assistant, you have this limited exclusion order, which is going to ban your products, but you also have the cease and desist order, which means you've got all these products in warehouses. I don't understand why you shipped all these products over to the US. It seems as though you were really stockpiling. And she said, that's exactly what we did because we understood these orders only affected customs. So we rented warehouses, we leased space, and we shipped this product in. And I said, well, you'll want to ship that back out or do whatever you can to get it out of the United States and stop advertising, et cetera. And she said, you foreign devil lawyers are not very good business people. Do you know what we spent to ship this product over there and rented these warehouses? We're going to keep selling. So I said, then I won't be able to help you. It's not something I would engage in. And I said, there's several reasons you probably don't want to do that, but I'll give you one that I think will get your attention. For each day that you have the product in the United States, each day you have it advertised on your website or whatever, the penalty is the greater of 2 times the value of the goods or $100,000 a day. So she went down the hall and she came back and she said, the boss wants to know 100,000 Taiwan dollar or US dollar. And I explained to her that it was US dollars. So they began an exportation program pretty quickly to get the product out of the United States. So those cease and desist orders are powerful remedies. And there are lots of strategic reasons you want to get one of those if you're suing at the ITC.
You answered my question as to whether there was a monetary penalty. How long do the orders last?
For the life of the IP. So with a patent, 20 years or however many years are left on the patent when you get your order.
Gotcha. So can you describe for us some of the differences between bringing a case before the ITC versus bringing it in federal district court?
Sure. I mentioned earlier there's more to do. One of the more to-dos is you've got to show at the ITC you have a domestic industry. So when Samsung sues a company in the United States, as they often do at the ITC, they have to show, for example, I have $1 billion fab, semiconductor fabrication facility in Texas. I have X employees, I pay taxes, I pay rent, et cetera. So they have a domestic industry. That's one thing you don't have to prove in district court. District court, I've got a patent, someone's infringing, I want to sue them. At the ITC, you have about 10 days to respond to discovery. In district court, you have 30 days or more. ITC, there are almost no limits on discovery, whereas you would have a limit on the number of questions you can ask the other side in writing called interrogatories. I think in district court, it's 21 or so. At the ITC, the minimum, most judges there put 175 as the limit. The commission rules don't put any limit. One judge now does a limit of about 31, I think, but most of the judges limit them only to 175. So discovery is much more wide-reaching and unlimited than in a district court, and you have a lot less time to respond to it. In a district court case, if you're sued on a patent, you often want to go to the PTAB, to the Patent Trademark Appeal Board, and file a paper saying, here's prior art. Someone invented this before these folks did. The patent office should never have invented this patent. They should never have granted this patent. So please consider this. Well, federal district judges, they're doing guns and drugs and all sorts of cases. And frankly, they find patents and many patent lawyers very resistible. So when someone comes in and says, why don't you stay this case, stop this, and let's go to the patent office, the district court is often happy to do that. They don't have to deal with the patents. They don't have to deal with these strange patent lawyers. I mean, they can let the case go off to the PTAB. The ITC does not grant those stays. So you're almost certainly not going to get a stay at the ITC. And you're going to have an exclusion order from the ITC before you can win at PTAB. You can rarely outrun the ITC.
So with all of that, I'm assuming there's been an uptick in ITC cases versus seeing them before the federal district courts in the patent.
I think there has been, Dan, because of the IPRs, the PTAB proceedings I was talking about, but also because of COVID recently. Of course, many people are not doing in-person jury trials. Judge Albright is doing one now involving Intel, as I understand it, down in Texas. But generally, people are still not doing in-person trials. They're doing video trials. But what they're also doing is, because their criminal docket, these judges' criminal docket, has statutory deadlines that the civil docket does not, and this would be civil, the patent cases are civil, you get punted to the back. I mean, we had a case, for example, a trade secrets case, that we were supposed to go to trial last year. The earliest we're going to get to trial is after Thanksgiving this year. So many people, they want quicker relief. So they go to the ITC and sue to get that quicker relief, to be in trial in a few months instead of a few years.
You know, you mentioned, Steve, that Intel case. I saw that it was the first in-person jury trial, patent jury trial since November, with all the huge backlog. To make a shameless plug for Roundtable Group, we did refer experts that were retained by Intel in that case. But
I hope you gave him a mask, Dan.
So
or two.
Right. So what's the best way for a respondent company to deal with an ITC case? Is there a silver bullet, would you say, in terms of, getting out of those cases before trial?
Well, I'd like to say it's the lawyer they pick, but that's not quite so. Getting a great expert, getting an expert who can talk to normal people and teach the technology and teach why your product or your new product does not meet the patents. But probably the real silver bullet is this new product I just mentioned. So you know about the patent now. You may have known about it before, but you know about it now. You know how the patentee is likely reading its claims to stretch and cover your patent, or just to cover your patent. So you come up with a redesign. And you want to get that redesign into the ITC proceeding before the judge to get it cleared. Because another oddity about the ITC is, until the order is issued by the commission, until the first trial before the administrative law judge, the patentee, the IP holder, has to map its IP rights onto the accused product. Once these orders issue, once the commissioners review it and do their work, once there's an order out from the commission, the patentee, the IP holder, no longer has to prove the other side infringes. Anyone who wants to import then has the burden of proving that they do not infringe. So the silver bullet, in my opinion, is a redesign, and a redesign that you get done very quickly. Now, we've done, 80 or 90 of these cases. My team has probably done over 100. Almost every respondent, when I say we need a different product or we need to consider a different product, no, we don't. We don't infringe. Well, the other side wouldn't be spending the money they're spending if they didn't think there was a good chance you do infringe. So the trick is to focus on a redesign while you're focusing on all the other things simultaneously. Get a redesign before the ITC judge. Get that redesign cleared. That's the silver bullet, in my opinion.
See, so you were selling yourself short. The advice you just gave just shows you that devil attorneys like yourself are really indispensable.
Foreign devil, not just devil.
So thank you, Steve. At this point, I'm going to open it up for questions. 2 questions for Steve Adkins.
Hello, everyone. Thank you so much for putting this up. Quite informative. So my question is basically, as you were talking about the ITC, and I remember the recent case of the Mahindra versus the Fiat Chrysler Group, where the trade dress of Mahindra's Rockstar car had to be changed, and ITC finally decided on that and gave an order. And Mahindra actually did change their car design, and they came up with it, and now they're able to sell the car over in North America. So my question is specifically, so does after changing the trade dress, does the order still have like a penal, provision or like a monetary penalty which has been put on the other, patentee infringer, or is it limited to just changing the trade dress and that's enough?
That's enough if you change it sufficiently. And again, there is no monetary penalty for violating the customs orders. That monetary penalty is only for violating what I call the inventory or cease and desist orders. But if you change it sufficiently, there is no monetary penalty. One of the benefits of getting a cease and desist order, however, is if you do not change it sufficiently and the commission finds that you're still infringing and you've been bringing this product in, then you face those substantial penalties. A good lawyer, a smart plaintiff will always try to get a cease and desist order if they can.
Is this limited to like the jurisdiction? If you bring in this only to the United States, when this will come into picture, or they can also work for a different jurisdiction? For example, if you're producing this in Japan and you're also importing the same in US, but you've stopped it in the US after the cease and desist order, but can you still keep on making it in Japan?
Yes, you can. We would like to think we have worldwide jurisdiction, but we really do not. So it's only for the United States. Now, there are people who have made products such as train wheels in China, and all of the infringing activity took place in China in this one instance. The products were brought here. There was really no infringement here because it was a patent on trade secrets and how these were made. Because the products were imported to the United States, they were blocked. But these orders only block products in the United States, not North America, not Canada, Mexico, just the United States.
Thank you so much.
Thank you, Manchu. We have another question in the chat from Kevin Webb. I believe this is for you, Steve. How involved does the ITC judge get into discovery disputes?
Depends on the judge. A lot of these judges don't like babysitting unruly lawyers who are disputing every dot and tittle. So some of the judges will make you go through certain discovery conferences to try to put a buffer between them and you. Some judges, before you can ever file a motion, they will say, you've got to get on a phone call with me, sort of like the New York courts do, the federal courts in New York. So they try to stay out of those if they can. They're not the most enjoyable thing in the world. But if they have to get involved, they will. And they'll get involved very quickly. And if you need something and you don't move quickly enough to get it, the judge will come after you for not having moved quickly enough, not having gone to the judge quickly enough, because these things really move quickly, these proceedings. So you have to get your discovery as soon as possible.
Another question from Steve Bauer, a question again for Steve. Could you tell us a bit about how to extend an ITC case to inducing infringement or contributory infringement claims?
The ITC orders can be based on both contributory and inducement, so it wouldn't really require an extension. There's some law, the Suprema case that came out recently, there's some Comcast decisions recently, where the infringing activities take place after the product is imported. And the argument was, well, there's no infringement until after it's imported. The commission found that their orders could bar that, even though the infringement wasn't happening at the exact moment of importation, if it's shown that the products come in only to be used in an infringing way, for example, the commission orders would certainly block that. Thanks,
Steve. We have a question for Thomas. Thomas, do you see a big change in the trade relations between the US and China with the new administration?
I think the Biden administration is probably going to be less erratic than the Trump administration in terms of what it does. And I mean, I read recently that whatever China pledged to buy from America under the deal reached with the Trump administration, apparently China has fallen quite massively behind on those targets anyway. But I I mean, I think there's going to be less erratic action from the Biden administration, but I think the general tone of the trade relationship is not going to improve. I think there's just enough consensus in Washington that China is a strategic rival. And I think the focus is going to be on the tech industry, continues to be on the tech industry to try to make sure that the US does not fall behind China in tech, especially things like semiconductors and 5G technology. So I don't see room for dramatic improvement, although we probably don't see unexpected things from the administration like we did with the last one.
Well, with that, I don't see any other questions. This concludes our discussion at the roundtable. I want to say a special thank you to you, Thomas and Steve, for sharing your knowledge and expertise with us. Thank you so much again, everyone.